Yes.
Well, yesterday I had mentioned an item for correction of one dead marine paragraph 24 and 26 in reachable number 2150 of 2024. That BBCL case, my lord. Well, if that actually this should be 23.
No, whatever, but record has not come. Yesterday, before 1 o'clock, I asked the courtmaster.
But
They said that the
yesterday also rose.
filing number was not available till 1 o'clock. As per information received from the courtmaster.
File.
I don't know. Till 1 o'clock, the courtmaster did not have the number.
Anyway, man.
So it could not have been sent.
Today I
Send it. Yes.
May I please? I like to mention for listing motion matter lawsuit filed on 17.
Give to the courtmaster, it will come up next week.
Yes. On 25.
May I please,
I don't know. Let the courtmaster take a call.
Lord, I have a prayer in item 23, my lord. It was a leftover item, my lord, on 13, my lord. Lordship will kindly take it up, maybe upgrade, my lord, after finishing of motion.
We don't know. We'll try, but we can't say right now.
Kindly be upgrade, possible. 23, my lord.
This is that we'll try to take up because your Vakalatnama apparently was defective.
Apparently was defective. My lord, I have checked, my lord, even the name of the petition number 6, my lord, did not match. Only, my lord, the surname, my lord. It was Begum in
We
the
don't know.
poster.
Let us see if we have time to take it up.
My lord. Indeed.
Lordship, I have filed one IA in a disposed case for extension of some time for compliance. I'm praying that be listed, Lordship. Not by this court, Lordship, court number 1.
May I please, Lordship? Lordship, I beg to mention a matter for listing in Division Bench 1, Lordship, on Monday, Lordship. Similar matter has been fixed there on 23rd, Lordship. Obliged, Lordship.
May it please, your Lordship. Similar prayer, Lordship. I have an urgency in this matter regarding Division Bench number 1, Lordship.
Okay.
I'll use it.
May I appear, Lordship? I'm praying for requisition of an IA. Requisition of an IA in connection with item number 2 and an additional bill.
May I please, my lord, I beg to mention for listing in motion column, my lord. Furnace matter, my lord. Most of it.
I beg to mention in item number 24, we filed an institutional affidavit, Lordship. That was not a tag, Lordship.
Lord, in item number 12, my lord, there is a typical error, my lord, the FT5 in place of FT4, my lord. In scene of
Okay. Do it.
item number 12.
Next.
May I please, your Lordship? Lordship, I'd like to mention item number 5 as well as 15. Lordship, since the late last night, Lordship, I'm suffering from allergy, so I cannot wear my uniform for a long time. I'm having that difficulty. So in item number 5, the LCR has already been received. If your Lordship is kind enough to fix it on Monday. And in item number 15, there is a difficulty because there's a time limit fixed by your Lordship. That the petitioner has to appear before the Superintendent of Police, Bozali, within 10 days. I made a mention on Wednesday regarding the issue, Lordship. So if your Lordship is kind enough to take it as a first item number 15, I'll go to a doctor immediately after your Lordship take up that matter, Lordship.
We'll see if we can.
Lordship.
5 you want an adjournment.
Lordship.
Okay, item 5. On the prayer made by Land Counsel for the petitioner.
15, if your Lordship direct me to file an IA for modification of the order, I'll file it tomorrow, Lordship.
No, you don't need a liberty with the court.
Lordship.
Do you need a liberty to file an IA?
No, the difficulty is that, Lordship, the time limit will expire. The time of 10 days.
No, you see, I'm at a loss to understand. If you want to file an IA, there is no restriction.
Yes, absolutely.
That you have to take prior permission of the court to file it. If you want to do it, do it.
But for that, Lordship, tomorrow the 10 days will be over. That is the difficulty.
Okay, then let me take it up if you want, if you have time.
Lordship.
Item 5. Can we take it up on Wednesday?
Lordship,
item 5. List on, make it Wednesday. Okay.
Item 15, is it possible for your Lordship to take up as a first item, Lordship? Your Lordship can see it on my head also.
No, not as first item. After motions, we'll take it up, try to take it up.
Lordship. Obliged.
May it please, your Lordship. Lordship, I'm praying for listing of writ petition on Obliged.
Item 1 for motion.
May I please, Your Lordship? In this case, we have taken step, but respondent number six has not, we have not find any response from the respondent number 6. Therefore, kindly list the matter of the date.
Please repeat again. We did not understand. Please repeat again.
Respondent number 6 has not sent any response towards the notice. Therefore, kindly list the matter on another date.
Respondent number 6.
Private response.
6 is the private respondent, my lord.
6, we have not even issued a notice. Oh, acha, notice is issued. But when did you take steps? You have a proof of taking steps.
Yes, sir.
Show us.
We have taken one.
Step for promotion, yeah. August of meeting.
No, there is no note of taking steps.
Slip proceeding.
You find it out, will. We don't know how you are dealing with these matters. You have filed a criminal petition for, and then you don't even indicate how many copies you have given. Here in the type it is written, please find with here with one copy, a copy. If you give a copy to him, how will he take steps? How will he inform the other 4? I don't know. We are at a loss.
First, we adjourn for today.
You have the this CCTV.
CCTV footage I have received, I have got now. The relevant CCTV footage of that particular date when the petitioner entered the police station and when he gone out. That thing I have 3 recordings, Lord. I have.
Okay. Does it show that checks were signed in the police station?
But in one of the video we have seen, Lord, in fact, the petitioner along with his counsel, one of his friend and his son, they were all along there in the police station. And in the morning, from petitioner side, along with his lawyer and the friend and the son and the other persons, their lawyer, they had a meeting, not with the police person. Amongst themselves, they had a meeting, and they have ultimately done that. That thing is there without any intervention of the police.
Okay, just give that.
Not
Look into it.
Malo.
We'll take it up after that short 12 o'clock recess we take.
Malo.
After that, you just give the pen drive. We'll try to see in that.
A lot.
Yeah.
But there's some important timings I have noted, Malad. Those
Please share it with us.
Those will be relevant. Logic.
That will make our work easier.
Lordship. But this is a handwritten for.
It's okay.
Lordship. If necessary, I'll explain. But I'll take a copy and I'll give. That is the. I'll take a copy and I'll give.
Okay,
Lordship.
okay, we'll pass orders at 12 o'clock.
Lordship.
After we come from the short recess.
I'll just make a copy and I'll give. What copy? Copy.
No, it will be the plan.
Yes, item 2.
Lordship, I have praying for requisition in regard to one IA has filed day before yesterday, Lordship. And affidavit and reply has filed yesterday, Lordship. And that part has not been tagged, Lordship. So IA for Lordship hearing the petitioner uncle Lordship was detained since last 26 days, Lordship. So hearing Lordship that my friend learned counsel as a respondent number 3 has filed one FIR, Lordship, during the pendency of the criminal writ petition, Lordship. So
What have you filed?
one IA has filed, Lordship.
Okay, it's not here.
I'm not here, Lordship. Ought to be taken, Lordship.
Okay.
And affidavit and reply also filed yesterday, Lordship. And that part also not taken, Lordship.
Well, the allegation in this case is that the petitioner's uncle, he has been picked up by police without giving any arrest memo, without any reason. We have placed before the honorable court that he is a declared foreigner, and the honorable the learned foreigners tribunal DFU has already passed an order, and by virtue of that order, he has been kept in the detention center as on today. Now they have disputed that the person whom we have picked up, he is Amir Ali, son of Lalumia. And the person whom we have the order has been passed by the FT, he is Amiruddin, son of late Nur Islam. In our affidavit, we have annexed the verification report of the fingerprint. And
Let it come on record.
Yes. Father name is not mismatched, Lordship.
Otherwise, the person is in detention camp, and it is an admittedly the copy of the foreigners tribunal order I have already served on the petitioner.
So, Lordship, the father name is not matched, Lordship. So, on that way, the concerned police did not arrest, Lordship. And before arresting, Lordship, they should have to impose a search of the allegation, Lordship. So, very much honored in this regard, the petitioner uncle, Lordship, in this regard. So, section 47 is clearly violation, Lordship. And also, article 22, subclause 1 also clearly violation, Lordship. So, if there any allegation, the concerned police concerned ought to be before arresting, would have to impose a search of the.
No, he has not been arrested. There is no question of arrest, my lord.
You appear to be in deep trouble. Take it up on Tuesday then. Let that affidavit in reply.
Yes, Lordship.
Okay.
Yesterday.
Let the both sides are represented. Let the affidavit in reply filed by the petitioner be tagged with the record. You filed it when?
Yesterday, Lordship.
Okay, filed on. Yes, release date. Filed on 18. No, filed on 18.
Lordship, affidavit and reply yesterday, Lordship. And IA file, Lordship, yesterday, Lordship. IA number.
And interrogatory application file was also attached. Okay, 24.
If possible on Monday, Lordship.
No,
Yes.
Monday it's not possible.
Yes, Lordship. Much obliged, Lordship.
Item 3. Item 3.
Yes, he's been released. Chip, due to this illegal detention and the trauma caused by this detention, uh, Chip, they are entitled to get the compensation.
That will be rejected. Your name?
J.A. Sikdar.
Heard Mr. J. Sigdal and counsel for the petitioner. All the respondents are there. By filing this writ petition under Article 56 of the Constitution of India, the petitioner had paid for a writ of habeas corpus. Interlieu, seeking direction for release of the son of the petitioner, namely, Hasinur, alias Hachinur, was taken into custody on 25/5/2025 at about 11 a.m. by the border police under the superintendent of police with the border goes Gwalpara. And was subsequently lodged at the Kokrajhar Holding Center, care of 7th Assam Police Battalion, Saraikula, in the district of Kokrajhar. Full stop. It may be stated that by virtue of an opinion dated 17/12/2018, passed by the learned member, Foreigners Tribunal, Kamrup Metro, Mr. Pang, what is the correct nomenclature? Foreigners Tribunal second, Kamrup Metro, or Kamrup Metro second? How do you
FT second Kamrup Metro.
Okay. By the Foreigners Tribunal second, Kamrup Metro, Guwahati, in FT case number 600/2017. Page 16. Stop. Pursuing the said opinion, comma, the son of the petitioner had filed a writ petition which was registered and numbered as WPC 2546 of 2020. Next paragraph. By an order dated 7/6/2021, passed by the division bench of this court in the said WPC 2546 of 2020, comma, owing to COVID situation, by an order dated 7/6/2021. So I've already stated 7/6, so don't say. Owing to COVID situations, the petition, the son of the petitioner was granted bail on conditions as contained in the order dated 15/4/2020, comma, passed in WBC with implicate suo motu, bracket was 1 of 2020. Next paragraph. The learned counsel for the petitioner has submitted that the son of the petitioner had complied with the directions as contained in the order dated 15/4/2020, passed by this court in WBC suo motu 1 of 2020, comma, yet, comma, the son of the petitioner was arrested and disregarded with the order of bail passed by this court. So accordingly, comma, he submitted that the son of the petitioner would be entitled to monetary compensation. Next paragraph. The petition was filed on 4/6/2025. And this matter was listed on 6/6/2025. Accordingly, a notice was issued, including notice for the prayer of bail. So by order date 11/6/2025, this court had granted visitation right to the petitioner with his son with at least 2 family members. And by order dated 16/6/2025, this court had granted bail to the petitioner, to the son of the petitioner, Next paragraph. Next, by the learned standing counsel for the active matters has produced a copy of interdepartmental communication made by the senior superintendent of police, Gwalpara, communication dated 19/6/2025, addressed to the Inspector General of Police within bracket border, Assam, informing the said authority that in compliance with the order of this court, the son of the petitioner was released on 19/6/2025 after proper medical checkup, verification of the certified copy of the order, etc. Next, by the learned counsel for the petitioner, upon instructions, has also submitted that the son of the petitioner has since been released on bail. Next, accordingly, it is provided that the Superintendent of Police, Border Gwalpara, has complied with the order of the court, though there was an admitted default on part of his establishment, the establishment of the said authority to have arrested the son of the petitioner, namely Hasinur alias Hasinur, on 25/5/2025, despite order dated 7/6/2021, passed by this court in WBC 2546 of 2020. Next paragraph. In view of the fact that the challenge to the impugn opinion passed by the learned Foreigners Tribunal, second, Kamru Metro, Guwahati, is currently pending before this court in the proceedings of WBC 2546 of 2020, wherefore compensation to the son of the petitioner is refused. Next paragraph. The learned standing counsel for the FT matter shall transmit a downloaded copy of this order to the concerned respondent authorities. Next para, as the son of the petitioner has been released, comma, this habeas corpus petition has served its purpose, and accordingly this matter is closed.
Item 4 for motion.
May I please, your lordship? Lordship, this habeas corpus petition filed by the petitioner, lordship, because on lordship 30, lordship 25/5/25, lordship, at around 3 AM, lordship, by the border police of the Dorang district, lordship, arrested the petitioner's wife, lordship, and did not inform where she is, lordship. And now on 13/6/2025, lordship, the honorable court passed order lordship, kindly see order dated 13/6/2025, lordship.
Okay, our
Purpose
question
of-
is, have you been able to go and meet the
Yes, lordship,
detained
yes,
person?
purpose already served, lordship.
Okay,
Lordship, I dispose of the matter, lordship, and with liberty that lordship, that after every 15 days, lordship, to the petitioner may allow to be.
no, once you have visited and seen him, he is to be deported. The writ petition is dismissed. After that, you have no liberty. He can't be kept in the country. Once you visited, because now you'll have to follow the usual process of the authorities for visitation, not by way of order of the court. Mr. Payang, can you obtain information as to what is the procedure if somebody wants to meet? What is the departmental procedure now? Now, once he's in the holding center, there must be some mechanism available for the people to meet them.
The holding center is a new concept.
No, we don't know, but that's why just ask someone and then tell us.
I'll get the information. We'll close the matter, but we'll ask Mr. Pang to get information.
Lordship. There's a 9-month-old lordship baby with the petitioner's
We
wife.
can't help it. That is something we can't help. How, Mr.
Yes, Islam, lordship.
S. Islam,
Yes, lordship.
Learned counsel for the petitioner. Next paragraph. Not next paragraph, I continue. Also head so and so for the respondents. Next paragraph. By filing this petition under Article 226 of the Constitution of India, the petitioner has invoked the habeas corpus jurisdiction of this court for alleged illegal detention of Manikjan Begum, Manikjan Begum, the wife of the petitioner, on 25/5/2025 Oh, no, we cannot close it. The authorities had granted him bail.
Was it bail order rescinded?
Yes, Lordship, she was released on, after 2 years of detention, Lordship, she was released on bail.
No,
As
that's
per-
okay.
as
That's
per
why we
Supreme
are
Court
asking
Lordship.
Mr. Payne. Mr. Payne. He's projecting that the jail authorities had granted, the detention center had granted him bail.
Yes, Lordship.
Now then we'll have to,
Waiting for deportation, but they were granted bail because at the time, the deportation process and the police was there.
but then somebody must recall that bail order. Was it done? You see, only because of Mr. Mahmood, only because of my bad habit of reading documents, I have come to know that he was granted bail by the authorities. In your synopsis, you don't write that. It is only because of my bad habit that I come to know that somewhere inside you have said that he was granted bail.
It is
Why you are writing a synopsis like that?
synopsis, it is written, my lord. It is written in synopsis.
In the synopsis?
Yes, kindly see first, last part. When she completed 2 years of in detention camp, she was released on bail from the detention camp.
Okay, I'm sorry. Just heard so and so. Next paragraph. In paragraph 4 of the writ petition, the petitioner projects that after an ex parte opinion was passed by the Foreigners Tribunal, by the learned member, Foreigners Tribunal 4th, Darang Mangaldayi, page 12, in case number so and so. The petitioner's wife, namely Manikjan Devi, was taken into custody on 13/4/2018. Asserting the said opinion, WPC 6290/2018 was filed, which was dismissed by order dated 14/9/2018. The said order was unsuccessfully challenged before the Supreme Court of India, which was dismissed by order dated 1/7/2019, passed in SLP within bracket civil, bracket with diary number 10587 of 2019. Next paragraph. However, on completion of more than 2 years of detention, the superintendent of the detention center at Tejpur released the wife of the petitioner in view of order dated 10/5/2019, passed in WBC 1045 of 2018. Give a dash and then Supreme Court Legal Services Committee versus the Union of India and others. Next slide is projected that on 24/5/2025, the wife of the petitioner, along with 9-month-old minor daughter, were apprehended and taken to Dhula Police Station, DHULA Police Station. And she was allowed to return on 24/5/2025. So, however, on 25/5/2025, she was again picked up with a minor daughter, and her whereabouts are not known. Next paragraph. Pursuant to the orders of the court, it is recorded in the order dated 13/6/2025 that the Learned Standing Counsel for the Home Department and NRC had disclosed that the wife of the petitioner, along with a 9-month-old girl child, maid daughter, are presently lodged in the holding center at 7th Assam Police Battalion, Soraikola, Kokrajhar. And accordingly, the petitioner and 2 other persons were granted visitation right to the petitioner to meet his wife and to obtain a wakalatnama, to be duly identified by the concerned official. Next paragraph. In view of the projection that the wife of the petitioner was released on bail, as indicated above, we direct the Standing Counsel for the FT matters to obtain instructions as to whether, on completion of 2 years of detention, the wife of the petitioner was released. Wife of the petitioner, namely, given name Manikjan Bibi, is allowed to go on bail by the superintendent of the detention center at Tejpur. Pursuant to order dated 10/5/2019, passed in WBC 1045 of 2018. Next part, the done it. Accordingly, the Learned Standing Counsel for the FT matters shall send a downloaded copy of the order to the competent authorities just to obtain instructions as regards the release of the petitioner, wife of the petitioner on bail. We are listing it on Wednesday, Wednesday will be 25/6.
My lord, one Manikjan Bibi alias Manikjan Begum. Kindly that may be added. Somewhere Begum is also written. Kindly see page 14. Manikjan Bibi alias Begum. That will be sufficient.
Okay, Manikjan Bibi alias Manikjan Begum. Okay.
Hello.
Item 6.
Yes.
I am awaiting instruction. I last spoke with my client on 15th. On 15th, he said that on 16th, he will be handed over to the Nigerian embassy. And yesterday night, I spoke with the SI. He said that they have handed him over to the Nigerian embassy on 16th.
Yes. Any further information you have? No. But please get it. Because unless the procedure is over, we can't close this writ petition. Mr. D.K. Agarwal and counsel for the petitioner is present. And he has submitted that when he last spoke to the petitioner on
15th.
15/6/2025, he was supposed to be handed over to the Embassy of Republic of Nigeria, Federal Republic of Nigeria, on 16/6/2025. So after that, he has no contact with the petitioner. Next paragraph. Accordingly, we request they just say all the respondents are represented, Mr. Payang, some MR Adhikari CGC, and Mr. P. Sharma, additional senior government advocate, are present. Next paragraph. In view of the submissions made by the learned counsel for the petitioner, we request the learned CGC to obtain information as to whether the process of handing over of the petitioner, namely so-and-so, to the Embassy of Federal Republic of Nigeria has been completed or not. Next paragraph. He is permitted to send a downloaded copy of this order to the competent authorities in the MHA of the MEA to obtain necessary information. Next paragraph. List on. It will be last day. You make it in 26th. 26/7. 26/6. Last day I may be in a mood to take more rest.
Item 7.
Yes. Yes, you filed an affidavit.
You also could find that.
You're filing today only.
We'll file a reply, my lord. I have been served a copy. In the meantime, my lord, I may be given a visitation right because I need to ask because there is an allegation that I did not appear since one of the detainees did not appear since December 2024. My instruction was that he was appearing. One visitation right, my lord, I will take all the information for the affidavit, my lord, and reply.
And Mr. A.W. Amal and counsel for the petitioner. So and so for the respondents are present. Mr. Chaudhary, you will be appearing. Mr. R.K.D. Chaudhary, DSGA. Next para. The learned standing counsel for the FT matters has submitted that
The voter is fine.
FT.
As the voter.
No, I am just recording yours. So has submitted that that only today an affidavit by the Superintendent of Police within bracket border, which place? Kamruk. Has filed an affidavit in opposition. Most of the said affidavit is no, don't say anything. Next para, the learned standing counsel, the learned counsel for the petitioner prays for allowing the petitioner to visit the detained persons, namely MD Abu Bakar and Akbar Ali,
Worker Siddiq.
who are presently lodged in the holding center at 7th Assam Police Battalion, Saraikula, Kokrajhar, together with at least one more family member and an advocate, so that necessary instructions can be taken. And thereafter liberty to file an affidavit in reply in the matter. Full stop. Next prayer is allowed. The liberty is granted to the petitioner, namely Torab Ali, visitation right to meet Muhammad Abu Bakar, APUBAKKAR, and Akbar Ali, who are presently lodged at holding center at 7th Assam Police Battalion, Saraikula, Kokrajhar, along with one family member and one advocate. Accordingly, it is provided that on the production of a certified copy of this order from the in charge of the holding center at 7th AB Battalion, Saraikula, Kokrajhar, shall allow the visitation, will allow the petitioner to visit the detained persons named above, along with one family member and an advocate. Next para, liberties are also granted to the petitioner to file affidavit in reply, if so advised. List on 14/7/2025.
Can be before vacation.
We will not have time.
In the meantime, I may not be pushed into Bangladesh. I may not be, the detainees may not be pushed into Bangladesh. I am not against deportation, my lord. That's a legal process, but pushing into Bangladesh is an arbitrary process. That may not happen.
But that the writ petition was disposed of. We can't do anything now.
Lord, I am only against pushing back into Bangladesh.
But we can't control that. That is not within our control. Once you've been detected as a foreigner and then there's an opinion.
My lord.
If we make any observation in a writ petition, that would work contrary to the provisions of law.
But my lord, that process is a deportation. But that is the process is deportation.
If
I'm
we
not
can,
against
we can,
that.
we can say something only when it is illegally made. Now we can't presuppose
My lord.
that they would be illegally pushed back. Presumption of illegality against the state is not available.
That is happening routinely. That's why
I
I'm praying
understand.
into your lordships.
Mr. President, first off, liberty granted to the land council for the petitioner to make a mention if for out of turn listing.
My lord. Grateful. Man.
Item 8.
Lordship.
Yes, Mr. Mazumdar. We will have to issue notice.
Find any grounds on which they can challenge the virus of the in this case. These persons were challenging it, they were provincialized in the year 2030. They say that we should have our seniority should be considered in the year when we first joined the initial school when it was not provincial.
There's one more matter, similar matter.
For a virus, challenge of the virus of the rules.
But even in this case, I think the state has also challenged some orders. No.
Had it been the lack of competency to do it, had it been any other provision under which they could have challenged the virus itself? Prosecution notice will come up with an affidavit, no difficulty.
We'll have to issue notice once the challenge is made. In this book, which page it is? Assam Secondary Education. Okay. Okay, we have got it.
Lordship. Actually, I have a request that matter should be taken after some time as senior counsel is on leg in the other court.
Just a moment. This is the case where these two schools were merged with one.
Happened is these were teachers in venture schools. Provincialization Act came in 2011, 2013, they were provincial. They had the qualifications to be treated as graduate teachers. They were given the posts of graduate teachers with their pay scales. Like Lordship has placed 35 of the rules. 14 is the rule that they are trying to change the proviso.
Yes.
Seniority will be counted from the date that they receive the graduate scale of pay. So on their entry into service, they receive the graduate scale of pay. Their claim is that teachers
their seniority should be counted from the day they first entered the venture school in the year 1991, 1992.
That is not permissible.
That is what they are asking. And therefore they are challenging the virus of these rules. That cannot be a ground to challenge the virus of the rules.
Okay, let Mr. Mazumdar come. Sorry, Mr. Bhuya come.
I was only objecting because the pendency of a case put the Department of jeopardy in proceeding with the
We understand. I was confusing with something else.
No, that is a different.
That was a different case. Okay.
Try amalgamation from when the seniority is to be found.
It's okay. There's
Unless-
some short circuit here.
Item 9.
Pursuant to the Lordship's order, but they were able to visit and obtain the wakalatnama also.
Okay. Should we keep it alive or we can
My lord,
close it?
because the petitioner was released on bail, my lord, therefore, my lord, and I have made a specific statement, my lord, she was following all the terms and conditions, my lord. There was no violation as such, my lord. Para 13, my lord, I have made a specific statement when I last visited, my lord. And I have also made, my lord, that I was visiting every week, my lord, to the police station, my lord.
You are referring to which document?
My lord, page 31 is my release order, my lord. Or bail, my lord. My lord, pursuant to the order, my lord, 2 years detention, my lord. An extra 6.
Okay, then we have to get information
Yes.
about his regular visitation.
Yes, my lord. Paragraph 13, I have made a specific statement, my lord.
Paragraph 13.
13, my lord.
Okay. Mr. M. Dattar and counsel for the petitioner, all the respondents are there. The learned counsel for the petitioner has submitted that pursuant to order dated 9/6/2025, the petitioner has been allowed to meet his father, namely Abdul Sheikh, Abdul Sheikh, at the holding center under 7th Assam Police Battalion, Saraikula, Kokrajhar. Next paragraph. The learned counsel for the petitioner has also submitted that pursuant to order dated 15/4/2020, passed in WPC within bracket Suomo 2, bracket clause 1 of 2020, on completion of 2 years of detention, the father of the petitioner was released on 30/4/2021. It is further submitted that a specific statement is made in paragraph 13 of the writ petition that as per the conditions imposed in the release order, the father of the petitioner has been appearing before the Kajal Gaon, KAJOL GON, PS every week. And his last appearance before the said police station was on 21/5/2025. Accordingly, it is submitted that as the father of the petitioner is complying with the conditions of bail, he is pressing the prayer for bail. Next paragraph. In view of the specific averment made by the petitioner that his father has been attending the Kajulgaon police station every week, in terms of the order of bail, we direct the court is inclined to direct the learned standing counsel for the FT matters to send a download copy of this order to the Superintendent of Police within bracket border. Which place? Superintendent of Police border. Which place? Chirang. To inform the court as to whether the father of the petitioner, comma, namely, comma, Polan, Polan, Polan. Oh no, what is the name of your father?
Abdul Sheikh.
Abdul Sheikh, ABDUL, Abdul Sheikh was detained by the Kazalgaon police station on 25/5/2025, had been regularly appearing before the Kazalgaon police station every week pursuant to his release on 34/2021. Comma, for which the learned counsel for the petitioner relies on Annex 6 to the writ petition. Full stop. Instructions instructions in writing. What are the instructions? Next, we are awaiting the instructions in writing, comma. List the matter on Wednesday. Miss up by Wednesday, list on. Make it Wednesday, 25/6/2025. You said instructions in writing.
He was probably detained in the strength of order that BNP and FT CHR 20 of 2007 and that opinion was never challenged properly. And here copy to your lordship.
No, you see, I think your authorities should be well advised whether or not there is a challenge or not. But pursuant to the Supreme Court order and the order of this court, they were all released. Now you have not prayed before the court to recall all those release or order granting bail. So once they are on bail, then you'll have to follow the due process or to take them into custody again. So somebody must have been overlooking this, or nobody thought that you have to get an order of the court cancelled or recalled before arresting them. In all these cases, you file, if you are so advised, application for recalling of the bail orders.
That the instruction.
Okay. Next.
Time being item 8.
I'm sorry, my lord, I was.
No, it's okay.
My lord. My lord, a very specific provision of the rule 14(2) is under challenge, my lord. What
That
they,
can't be permitted. You will create a disturbance in the entire state of Assam.
no, my lord, we are not praying for any interim at this moment. my
No,
lord.
no, but it can't be maintainable. Before you enter service, you want a seniority from that date.
No, my lord, before, not for, my lord, the issue is that they are saying that the graduate scale of pay should be the date of counting the seniority, my lord. That is the, my lord, provision made under
But
the
when
rule
you enter
14(2).
service, but when your service is provincialized,
My lord.
can that happen prior to that date?
No, because, my lord, what they have done, they have taken into account the initial date of appointment for my provincialization, my lord.
Correct, has to be.
That is, so that's why, my lord, if the part of that initial date of appointment has been taken into account, my lord, so why, my lord, the seniority should be counted from the date of receiving the graduate scale of pay, my lord. That is our contention, my lord.
That's why we said you will be disturbing the entire fabric of the state, because this is not the only school in the state to have been provincialized. Once this 14(2) goes,
My lord.
what happens to thousands of people?
My lord, such type of, it will run prospectively, my lord, if disturbances
No.
is there, my lord. My
No.
lord, my lord, what has happened, my lord, certain rules, similar cases are also being pending, my lord, before this honorable court, my lord. My lord, may I pray, my lord, can it be taken up on next week, my lord? I'll try make an attempt to satisfy my lord, my lord.
You find that I am thick-headed today.
No, my lord, that is, my lordship is already overburdened with lots of FT matters.
No, we are not overburdened.
My lord.
Can a overburdened man smile and laugh like me?
No, my lord,
No.
my lord, I always, my lord, please, arguing before my lord, my lord. Only thing, my lord, is that the issues, certain judgments are there which are not equipped today with me, my lord. Some personal
Okay.
difficulty to my lord.
So you will manufacture it?
No,
Overnight.
no. It is already there, my lord.
Okay,
but-
already there.
No.
Okay. On the prayer made, on the prayer made by Mr. A.R. Bhuyalan, counsel of the petitioner, list after, next week is too troublesome. To take up virus, challenge of virus.
My lord.
Can we have it on reopening?
My lord.
Okay, on 14/7, we are giving it on the opening day.
My lord.
14/7/2025. Next, Mr. R. Masundar and Standing Counsel for the School Education Department is present. Okay.
Oblige, my lord.
You know why you are fixing it on that day? That day you can't say that I am overburdened. If it comes to this bench.
I'm sorry for that word.
No, not that.
My lord.
Not that. I don't take an offense of these things.
My lord. Oblige, my lord. Highly oblige.
Oblige.
Item 10.
Here also, my lord, the petitioner could visit, my lord. And my lord, here, of course, I could not annex the order, my lord. He was released on 15/11/2011, my lord. I could not annex the order of release, my lord, but he was released on 15/11/2011, 21, sorry. And my lord, I have made a specific statement, my lord, that he has been visiting the police station, para 12 and 13, my lord. Page 8, my lord, of writ petitions.
You have been allowed to visit.
Yes, ma'am. I could take the Wakalatam also, my lord.
Then you can close this matter.
No, well, same prayer, my lord, since my lord, she was on bail, my lord. But I could not annex the order, my lord, because of that 2 years having completed 2 years, my lord, she was released on bail, my lord.
Okay. But
Mr. M. Datar and counsel for the petitioner. That order was passed in item 9.
Nine.
In item 9, it will be almost same. Mr. M. Datar and counsel for the petitioner. All the respondents are there, including Mr. Arkady Chaudhary and a DAGI. Next para. At the outset, the learned counsel for the petitioner has submitted that pursuant to order dated 9/6/2025, passed by this court, the petitioner has been able to meet her husband, namely, Majibur Rahman alias Majibur Sheikh at the holding center at 7th holding center under 7th Assam Police Battalion, Saraikula, Kokrajhar, and also to obtain the Wakalatnama. Next para. By referring to the statement made in the writ petition, it is submitted that by virtue of an opinion dated 15/7/2019, passed by the learned member, Foreigners Tribunal, Chirang, in FT case number, this is page 16. The husband of the petitioner was declared to be a foreigner of post 25/3/1971 stream, and he was taken into detention. Full stop. However, by virtue of order dated 10/5/2019, passed by the Supreme Court of India in WPC 1045/2018, give a dash, Supreme Court Legal Services Committee versus Union of India, the petitioner was granted bail. It was released on bail. Full stop. It is submitted that on 15/11/2021, on completion of 2 years in the detention camp, the husband of the petitioner was released. Full stop. Referring to the statements made in paragraph 13 of the writ petition, it is submitted that the husband of the petitioner has been appearing before the Kajulgaon police station every week as per terms of the terms and conditions of the order of release. And the husband of the petitioner has last appeared before the said police station on 21/5/2025. Next para. In view of the said assertion, the United Standing Counsel for the FT matters shall send a downloaded copy of this order to the concerned authorities so as to obtain written instructions as to whether the husband of the petitioner, namely Majibur Rahman, alias Majibur Sheikh, has been compliant with the conditions of bail. By appearing before the Kajalgaon police station every week. Full stop. Awaiting receipt of written instructions, list on 25. Okay.
Item 11.
In this case, my lord, submission was made that he was handed over to the APB, the Border Security Force, BSF. But what happened, yesterday when informed, about 2-3 days back, he was found in unconscious state near Bijni. He was found in an unconscious state in Bijni. He has come back home. And he was from there, the villagers brought him back home. He's with Milord at home. I've asked the petitioner to be present, to file an affidavit. He's on the way, today. He's supposed to come.
You file it, then
We will file an
consider
affidavit
that.
from that.
Mr. M. Tatal and counsel for the petitioner has, upon instructions, has submitted that under that in an unconscious state, the father of the petitioner, namely Bakar Ali, has been recovered from Bijni and he has been brought home. Post op. He submits that he is awaiting appropriate instructions, appropriate and complete instructions in the matter. And to file an affidavit if so required. Post op. You say all the respondents are represented. Next para. In the meanwhile, give the names of the council appearing for the respondents. And say Mr. Arkadi Chaudhary and ASGI. Shall also send a downloaded copy of this order to the concerned authorities in the BSF to obtain information about Bakar Ali, who's reportedly who's stated to have been handed over to the in charge of the sector headquarter, BSF, Panbari in the district of Dhubri. Regarding this detained person. Next para. List on 16/7/2025. To also get information, if you are handed over, how could he be found elsewhere?
But so far as the status of the his father is concerned, he's at home. If anything is to be produced before anyway, we will comply with the direction as your lordship, please. Because he's at home now. Because he was released after 3 years of being condition, in terms of Supreme Court's order. And he was also visiting the police station on a regular basis.
If that way, you can record his presence before the Superintendent of Police border. Which place?
It will be Dhubri, Chirang, sorry.
Chirang. Before this direction to Mr. Arkadi Chaudhary, before that you write, under the circumstances, we direct that the petitioner shall produce his father, namely so and so, before the office of the Superintendent of Police, border Gwalpara, Chirang.
What would I try to be sure that will?
Lisa, the Harry form of Harry visitor. That was instruction given by Harry. Last one was a reflect for us.
By producing a certified copy of this order before the said authority, Mr. Datta, you see, I'm just thinking aloud. You see what has happened? The state has given it to the center, and from there he is again home. If we pass an order directing Mr. Chaudhary to get information, definitely the authorities may take a view that he has absconded and he'll be rearrested. He'll be taken into detention again. So if he is back home, you think over, we'll give you time. Would it be appropriate to close the matter just and then because if they pass an order, then something is going to happen.
It's my duty to point out everything.
No, that's okay. But think over what
Understand.
would happen if we pass the order.
But he was sent back and he came back again.
No, that's why please take a call. I will give you 10 minutes time. You can come after 10 minutes, we examine. Mr. Chaudhary, let him think over what would be best course. That's why we were.
He is again found inside. He has to be taken.
No, the question of handing over, that's what I'm saying. Milord. The question of handing over has a Milord, procedure that has been Milord, professed by the state. The state has said that we have this particular procedure of handing over people. Whether that procedure was followed and he was handed over,
No,
that's
we
another
don't
issue.
know what has happened, but there may be a fallout of the order passed. Think over because we have after that we have no control over it.
Understand that, madam.
Take a break and come back in the meantime and think over.
Well, that's
Mr. Sharma, this pen drive we could not open. The video file is not there. It is perhaps in some other format. It in HTML. We have tried to open in HTML. That is also not opening. Maybe some other format. It doesn't work here. You'll have to ask Mr. Nath to try to operate it here so that after we rise, so that we can see it. Yes. Okay, after some time. Yes, item 12.
May I please, Lordship?
Yes.
Milord,
Annexure 1, my lord, page 17 to 19, my lord. My grandfather name is enlisted in final Khotion.
No, don't start from there. What you are challenging here?
That impugn opinion is page 61 to 74, my lord.
Page?
Page, my lord, 61 to 74, my lord.
61 to
Annexure 19,
74.
my lord. My lord, relevant portion
It's at
is,
23. You'll have to wait for some time for bail.
my lord, due to the financial hardship, my lord, she could
We
not.
can't help it. To 2023, we are not granting bail right now.
But due to poverty, my lord, they could not
We
find.
can't help it. Rather, you can surrender before the police that the poverty will not come into in your way. At least you will have for 3 square meals. 2023, we are not granting you bail on no condition. Rather, we are putting you to notice on the issue of delay in latches.
That I have stated in para 2, my lord.
We put it to notice, we'll hear it on this day. Heard, Mr.
As Islam, my lord.
As Islam and counsel for the petitioner, all the respondents are there. By filing this writ petition under Article 226, it's page 61, opinion dated 16/5/2023, passed by so and so and so and so. IMDT case number so and so. They were declaring the petitioner to be a foreigner post 25/3/90 on 71 stream. Notice returnable on 25/7/2025. Extra copies within 2 days. Let the relevant the relevant records be requisitioned from the concerned tribunal. Next by the bearer for bail shall be considered on receipt of tribunal's records. Next by list on 25/7/2025.
My lord, there is one typical error, my lord. That is FT 4, my lord. In place
We
of
allowed you
FT
to correct it. In the morning when you made a mention, we allowed you to correct it. Do it. Correct their copies also. Correct their copies also. Yes, item 11.
What I pray, my lord, let this said time, my lord, I file an affidavit, my lord. In the meanwhile, my lord, lordship will pass an order, my lord, that they will not detain him without leave of this court, my lord.
No, that can't be passed because once you once that order has attained finality,
My lord.
that protection will be counterproductive to the law.
But then, my lord, she was released on bail, my lord, on the condition that he had completed 3 years of bail, my lord. Now, because what happened, my lord, this order which was passed by the Honorable Supreme Court, that was not because of COVID, my lord. That was an order passed in 2019 before COVID came on the ground of long detention because they were not deported. 3 years, and those who have completed 3 years, they were allowed to be, my lord, released. Now, that release order, my lord, is still
You see,
valid.
this release order doesn't come in the way
My lord.
for the state to apprehend you and to deport you.
Yes, my lord. We should, my lord. We are not, my lord, on the, my lord, we are not saying that they cannot be deported. If, my lord, they are deported in a proper manner. The state itself has, my lord, filed an affidavit in the Supreme Court giving the state, my lord, exact, my lord, details, how they, my lord, propose, my lord.
Will say they will follow the US procedure.
The US procedure, my lord, they did not do it stealthily, my lord. They brought them in the airport and dropped in India's airport, my lord. It was not done in the manner, my lord, in which it has been done in this cases, my lord. So therefore, there is a fundamental difference, my lord. They did it, they brought these people with on plane, my lord. Maybe in inhuman condition, my lord. But they dropped in Indian airports, my lord. Now, as per, my lord, the stand of the state, my lord, there's a procedure of deportation, my lord. That is, but that I have brought in by an additional affidavit, my lord. That the entire stand, my lord, has been given in the affidavit itself, my lord. They have
Okay, then
specific.
we put you to notice. Then same order will be there. That same order will be there, and
You say in the event, in the event, the father of the petitioner is sought to be deported, comma, the proper procedure be followed in the process. List on. What did we give? Did we give? 25. Okay.
In the meantime, he did with regard to his detention, madam, since his home, madam. That is
We are not saying anything because now we're giving you a positive order.
Madam.
We'll follow the procedure to
Madam.
it.
Oblige, Lordship.
Or 16th of July. Okay.
Madam.
Supplementary item 72.
May it please, your lordship. Lordship, this is a case where your lordship, my wife has been picked up on 26/5, your lordship. Admittedly, your lordship, she has been declared foreigner by the Foreigners Tribunal Jorhat, your lordship. Thereafter, your lordship, that order remained unchallenged, your lordship. But on 26/5/2025, your lordship, she was being picked up, and since then, your lordship, no one is informing us regarding her whereabouts, your lordship.
Okay. But Mohammed I. Hussain, and counsel for the petitioner. All the respondents are there. Next para. The case of the petitioner is that by an opinion dated 10/8/2022, the wife of the petitioner, namely, Rabia Begum, RABIA Begum, alias Rubia Begum, RUBIA Begum, was declared to be a foreigner, which was passed by the learned member, Foreigners Tribunal Jorhat. In case number, where is that opinion?
Your lordship will find on page 11.
Page 11. Stop. It is projected that the said opinion remained unchallenged. Stop. However, on 26/5/2025, police personnel from Golaghat police station had taken the wife of the petitioner into custody, and since then her whereabouts are not known. Next para. Accordingly, we request the standing counsel for the FT matters to obtain information about the wife of the petitioner, namely, Rabia Begum alias Rubia Begum, against whom an opinion dated 10/8/2022 was passed by the learned member, Foreigners Tribunal Jorhat, in case number so and so,
who was stated to be apprehended on 26/5/2025 by the police personnel from Golaghat Police Station. Next, the Land Standing Counsel for the FT matters is permitted to send a downloaded copy of this order to the political, home and political, or to the political and home within bracket B department to obtain information list on Monday.
We are not sub copy and we are not sub copy my lord in this case.
A copy is not there.
Because my lord, probably they were thinking that we will not appear in this. Otherwise, my lord, the.
No, Mr. Hussain will not do that.
Right.
He's missed it somewhere. Give a copy.
I'll provide copy, Your Lordship. I'll provide copy, Your Lordship. Actually, Your Lordship, this is a habeas corpus petition, Your Lordship.
That's
So,
why, my lord, they are not making us copy.
so Your Lordship, we have made the police authorities the parties, Your Lordship.
So once there is an opinion, they can do and they cannot do anything.
Lordship. So,
You give it to,
yes, Your Lordship, I'll
give a copy to him.
I'll provide, Your Lordship.
Starting copies for one person.
Your Lordship, may I pray, Your Lordship, if not deported, she may not be deported, Your Lordship.
If there is an opinion, we can't pass that order.
Your Lordship, she is yet to exhaust all the legal remedies, Your Lordship. We are.
No, that's okay. We won't comment on that. Let this come on Monday with that information. After that, we give you visitation, right? Then you.
Lordship. I'd like to, Lordship.
Wednesday will be too long.
Tuesday.
Make it Tuesday then.
Tuesday. Lordship. Lordship, I'll provide copies. Like.
Item 73.
Just say that Mr. J. Pine standing also for that. Give the name. And one more word. The issuance of notice is deferred till the next date of listing, list on so and so. It's okay. There's a procedure part we had ways to follow. The issuance of notice is deferred. We have to put it in the order because it's a habeas corpus. So that's why the procedural part has to be completed. Yes, Mr. Bhuyan.
May I please, as a lordship? My lord, I had been declared by an opinion, my lord, long back on 11/11/2016. Was a my lord foreign national. My lord, I have annexed that at page 17, annexure 1. The husband of the petitioner has been declared, my lord. And thereafter, my lord, this order had again been put into
Okay, we're passing the same order. We'll get your whereabouts.
My lord, right now, my lord, we even make copies, but my lord, please.
Okay, give a extra copy.
Right now, I've given.
Mr. A.R. Muhal and counsel for the petitioner. For the respondents there. In this case, the opinion will change. Opinion dated 9/6/2025. It's in page.
My lord, it is on 11/11/16 at page 17, annexure 1, my lord.
Page 16.
17.
17. Okay.
7.
Opinion is 11/11/16.
Yes, okay.
Passed by Learned Member, Foreigners Tribunal, Chirang.
Mal.
In case number so and so. P number so and so. They were declaring the husband of the petitioner, namely
Sohrab Ali
Sohrab
Pramanik.
Ali Paramanik, SOHRAB
Mal.
Ali Paramanik, PRAMANIK. To be a foreigner post 25/3/1971 stream. So it is submitted that the said opinion
was challenged before this court
WPC
by
7579.
filing a writ petition which was registered as WBC
7579 of
7579 of
2016 at page 30 million.
2016. However, they said the writ petition was dismissed
Order dated
by order dated
by Milord 35 2017.
30/35 2017.
My lord.
Next,
Page
Madam.
6. Okay.
It is also projected that the husband of the petitioner was taken into custody
On 25/5.
on 25. No. Before that,
Oh, yes,
taken into
Mr. Sir,
custody,
before that,
and thereafter,
yes, the conditional bail has been
uh,
at page 32 annexure 3 million. नाम को दो। Lord, I was detained on 11/11/2016, Milord.
and therefore, pursuant to communication dated 17/1/2020 issued by the Superintendent of Police within bracket border, bracket close Chirang, Kazilgaon, the husband of the petitioner was released on conditional bail from the detention center Goalpara. And he was released on which day? Same date.
My lord, my lord.
And he was released on the same date.
Same date, my lord.
Full stop. It is further projected that on
Milord, we have stated it's Milord.
on which date you were apprehended now?
Milord, on 25/5/25 with
On 25/5/2025,
Why?
the husband of the petitioner, namely
Sorab Ali
so and
from
so, was taken into custody and his whereabouts are not known.
my lord.
Next paragraph. Accordingly, because the Mr. J. Pangal understanding us for the FT matters to obtain instructions as regards the whereabouts of the husband of the petitioner, namely Sohrab Ali Paramanik, alias Sohrab Ali Paramanik, and alias also at page 3. Against whom an opinion dated 11/11/2016 was passed by the London member, Foreigners Tribunal Chirang, in FT case number so and so, who's stated to have been detained on 25/5/2025.
Mine.
So next paragraph, list on same Tuesday.
Yes.
Okay.
Obliged, Milord. Keep your post.
$74.
May I please, Lord? Lord, we have challenged the Lord impugned order that your lordship will find first order at page number 45. Order dated Lord 4/6/2024. It's 45.
Where is the previous orders of the tribunal?
Previous order, my lord.
Because here this order says that your has already been expunged.
Yes, 4/6, order dated 4/6/2024.
We don't know what is it referred here.
Yes.
In this page 45, you are making us read. There it says on this very date, without any bearing of habeas file petition without so and so, is not all acceptable, as already the stage for filing further evidence has been expunged.
Yes.
If that be so, then your writ petition is liable to be dismissed. Once the earlier order attains finality,
My lord.
subsequent order can't be challenged. So, madam, we are dismissing your writ petition.
The earlier order, my lord, we are having the my lord, copy.
No, the copy will not do. That's not under challenge. Even if you produce this order, it can't help you. This order is not under challenge, it become attained finality. You want me to dismiss or you want to withdraw?
Now, the earlier order not like that, my lord. It says, my lord.
No. Once you see, Mr. Mandal, you will produce one by one the orders. Why don't you have the entire order sheet so that we can understand what order is being referred to?
Yes, in that case, my lord, we will file additional affidavit, entire order sheet.
Do it, because
Yes.
one by one doesn't help.
Yes. Now,
In this court, it has happened uncountable times. When we see the earlier orders, we find that there were some orders which were required to be followed up and not been done. Not one. We miss at times, we miss out the note sheets. At times, at the time of hearing, after 5 years, in one case, I found that the notice on one particular person was not served. So I have a very bad habit of looking at the previous orders and orders when I'm passing orders. That leads to some difficulty. In my
Now,
court also, it happens a lot
yes,
of
my lord,
times.
by another, my lord, last order, lordship will find at page 50 on. My lord, the
No, you produce
official.
the order because we can't apply
Yes,
a
yes,
mind
we'll-
piecemeal basis.
Now, in the case, my lord, the next date is, my lord, 2/7/2025. For
We bring it tomorrow or make it on Tuesday,
my lord.
whenever you want. Mr. M.U. Mandal and counsel for the petitioner prays for liberty to file an affidavit to bring on record the previous orders of the concerned tribunal. First of all, list the matter as and when the said affidavit is filed.
My lord, we will file it Monday, my lord. Let it be posted on. Their part.
Okay, list on Tuesday then.
My lord. Oblige, sir.
75.
May I block it? Also, here ex parte opinion passed by the learned Diffuse tribunal.
Which
Page
page?
number 53, lordship, annexer 80.
Page,
lordship.
page
Page 53, lordship.
53.
Yes, lordship. Lordship, here, the bottom portion is define the notice could not be served to the opposite party due to procedural lapse, lordship. Last line of this page, lordship. But notice could not be served, lordship. So that's why ex parte degree has passed, lordship.
You want you want a soft answer from the court, or you want a what you call a burst out order from the court. What do you want?
Lordship, whatever.
I'm putting you a question. You want a soft response from the court, or you want a very harsh response from the court?
Soft response.
Soft response. Then next time when you appear before this court, please read the entire order and then tell us.
Absolutely.
Because the next line is, which you omitted, which amounts to misleading the court, is that after going to the case record, it is considered necessary to be revived the case as per decision of Honorable Guwahati High Court in so-and-so in Tutu Mia, and the case is accordingly revived on 10/3/2022 and issued notice fixing 10/2/2022 for service report, appearance and written statement. Accordingly, the notice were duly served as per provision of 3(5)(f). So next time, please read the entire order. Don't expect that this you could mislead the court. Because I may forgive. I have a simple principle. I can forget and forgive a sin, but I am trained not to forgive a sinner. Correct? Once you mislead the court, I will never forget you.
I'm not a misleading, Lordship. So yes.
Why did you read one line and stop it? That's why we asked you, you want a soft response from the court or you want a harsh response? Harsh response is once we find that you have misled the court, I can very well draw up a contempt proceeding right now. You want me to do it?
I'm sorry, Lordship. I'm sorry for that.
Don't be sorry. You don't learn from your mistakes. First things that a counsel should do is that to learn from the mistakes. You have not learned.
The valuable time of the court, Lordship. So that's why I have to, the relevant part I have to read. So
This is the relevant part. This is third time you are making that mistake.
I'm sorry for that.
In course of this submission, this is the third time you are making this mistake. Mr. R.C. Das, learned counsel for the petitioner, made an attempt to mislead the court by reading out only part of the order. To stop accordingly, the court is not inclined to take up the matter today. List on Wednesday. All the respondents are represented.
Yes. Master.
Yes, item 76. Just take a seat for 2 minutes.
My lord. Sorry for that.
Yes.
May I please, as a lordship, my lord, this is also in the nature of habeas corpus. Husband of the petitioner, my lord.
Okay, we pass the same order.
My lord, FT order is at page 18, my lord. Honorable,
18, okay.
My lord, Honorable High Court's order is at page 21, my lord. Release order is at page 26, my lord.
Yes, okay.
My lord.
Heard Mr. A.R. Rahman, counsel for the petitioner.
A.R.
I'm sorry.
Great musician.
It's okay. I made a mistake. I love that music and song, and therefore
my lord.
I made a mistake. A.R. Rahman, counsel for the petitioner, of the respondents is there. Next paragraph by. In brief, the case of the petitioner is that by
5/6/2017.
Opinion dated 5/6/2017, that is at page 18.
My lord.
Passed by so-and-so and so-and-so. Passed by London member, Foreigners Tribunal Chirang. In case number so-and-so, PE number so-and-so. The petitioner was declared to be who is this person?
husband,
husband of the
the
petitioner.
husband of the
his name
petitioner,
is,
namely is
my lord, Saha Ali, my lord.
Muhammad M.D. Muhammad
Saha.
Shaha Ali, was declared to be a foreigner post 25 in 1971 stream. Full stop. The said opinion was unsuccessfully challenged before this court by filing
My lord,
a writ petition.
4158 of 2017 at page
However,
21.
the said writ petition was dismissed by order dated 13/12/2018, passed by this court in WBC 4158 of 2017. Next, it is projected that thereafter the husband of the petitioner was apprehended
On,
and
on 5/6/2017, my lord, I was detained.
on 5/6/2017,
My lord.
the petitioner
And
husband of the
released
petitioner
on-
detained. However, pursuant to order dated 13/4/2020, passed by the Supreme Court of India in suo motu WPC number 1 of 2020, and order dated 15/4/2020, passed by this court in WPC within bracket suo motu bracket close 1 of 2020, on completion of 2 years of detention, the husband of the petitioner was released by
21
release order dated 21/4/2020, passed by the issued by the Superintendent of Police within bracket border bracket close Chirang, Kajilgaon. Full stop. Now, where is this statement made by you
My lord.
that you are complying with the bail conditions of bail?
Lord,
Which I think not there.
basic.
Next, it is submitted that in the meanwhile, the husband of the petitioner, namely
Saha Ali.
Muhammad Shaha Ali, has been taken into custody on 25/5/2025, and thereafter his whereabouts are unknown. Next, para. In view of the said projection, we request the learned standing counsel for the FT matters to obtain information about the whereabouts of the husband of the petitioner, namely, Muhammad Shahad Ali, against whom an opinion dated 5/6/2017 was passed by the learned member, Foreigners Tribunal Chirang, in FT case number so and so, and was released on bail pursuant to release order.
Dated 21/4/2022.
That is page number?
Page number 26, annexed figure.
26. Okay. Pursuant to release order dated 21/4/2020, passed issued by the Superintendent of Police within bracket border, Chirang, Kajilgaon. Next, the learned standing counsel for the FT matters is permitted to send a download copy of the order to the concerned authorities in the Home and Political within bracket B department, so as to provide such information. Next, list on Tuesday. Just before that, you say the issues of notice in this
habeas corpus petition is deferred till the next date of listing.
Mine. Obligement, deeply obliged.
77.
Please, your lordship. Lordship,
Yes.
the impugn order here is on page 85, your lordship.
Page number
85, your lordship.
85.
85, your lordship. Why this order, your lordship? The petitioner.
But we have to still wait for bail
Okay, order was passed.
till the next date. There's some delay in the matter,
24,
more than 1 year.
lordship.
Okay. But you'll get your records through email.
Lordship.
What I sent and counsel for the petitioner. The respondents are there. My opinion is at page 85, dated 8/3/2024, passed by so-and-so in case number FT so-and-so, SP foreigners case number so-and-so. This third one, police memo number so-and-so, by which the petitioner was declared to be a foreigner post 25/3/1971 stream. Next paragraph, the learned counsel for the petitioner submitted that there has been an inadvertent delay in challenging the impugn opinion. Next paragraph. Notice returnable on 25/7/2021. Extra copies within 2 days. The registry shall requisition the records from the concerned tribunal by usual process as well as through email, to be sent to the following email address of the concerned tribunal. Next paragraph. The prayer for bail shall be considered on receipt of records. However, it is provided that in the event the petitioner is apprehended, he should not be deported out of the country without order of the court. List on also. Item 15, there was a
Item
request to
15.
update the matter.
Lordship granted bail to the petitioner on 11/6/2025. Item 15, 1. Directing the petitioner to appear within 10 days, Lordship. However,
Yes.
Lordship, the SP order Bozani is not refusing, is not accepting the order because he says that it has to be submitted before the SP border Borpeta, because the reference was sent by the SP border Borpeta. Because it was sent in 2003. At that time, Bozali was not created. And the opinion was
Yes.
passed by FT Bozali.
The records are available under SP board.
Opinion.
Before the SP, 100 the records are available in the SP board of corpus.
But you can't be in Bozali.
But if the opinion was passed by Bozali, therefore there was a direction to SP border Bozali. Opinion was passed by Bozali, Lordship.
Number 6, well, probably immediately he has made party SP border Borpeta as a party. Yes, here in the
Respondent number 6.
It was sent by Borpeta.
Yes, Lordship.
But it should go to Bajali now. No, it is Borpeta only. This, where is this place? Borbara. Borbara is in Borpeta.
Borpeta.
It's not in.
The
Since the
direction
opinion-
may be made to Borpeta, SP Border Board.
Okay. But is Borpeta party here?
Yes,
Borpeta is
respondent number
party. That is not a party. That may be also another aspect.
Okay, okay. Okay. Heard Mr. R. Boral and counsel for the petitioner. Also heard counsel for the respondents. Next para. By the learned counsel for the petitioner submitted that by order dated 11/6/2025, this court had granted bail to the petitioner by providing that the petitioner would appear before the Superintendent of Police Border Bajali and take bail in terms of the said order. Next para, it is submitted that as per the contents of the opinion dated 24/2024, page 81, passed by so and so and so and so, the reference was made by the Superintendent of Police Borpeta, and it is submitted that when the petitioner appeared before the Superintendent of Police Border Bajali, or the said authority could not accept the bail on the ground that the reference was made by the Superintendent of Police Border Borpeta.
18 18.
Full stop. Accordingly submitted that on a mention being made, this matter has been listed today. Next para. Heard the learned counsel for the respondents. Next para, in view of the fact that as per the impugn opinion or opinion referred above, the reference was made by Superintendent of Police Border within bracket border bracket close Borpeta, and having noticed that the petitioner has implemented the Superintendent of Police Border Borpeta as respondent number 6 and not Superintendent of Police Border Bajali, the court is inclined to provide that to give further 10 days time from the date of the order to the petitioner to appear before the Superintendent of Police Border Borpeta and to take bail or rupees 5,000 with one sovereign security or like amount in terms of order dated 11/6/2025. Full stop. Next para, it is also provided that the reference to Superintendent of Police within bracket border bracket was Bajali, appearing paragraph 6, 7, and 8 of the order dated 11/6/2025 shall now be read as Superintendent of Police within bracket border bracket was Borpeta. Next para, this order shall be read together with order dated 11/6/2025 passed in this writ petition. We extend 10 days time.
Lordship. Obliged, Lordship.
List. List in the week commencing 21/7/2025.
Upgrade item 23 for orders.
Please, Your Lordship. Please, Your Lordship. Lord, I have gone through the office note, my lord. The name of the respondent was, my lord, petition number 6, my lord. Little bit, my lord, dissimilarity, my lord. Her name was Anjora, my lord, Begum. It was written in the course title. But while signing the wakalatnama, she had put her signature as Anjora Khatun, my lord. That is an inadvertent mistake on my part, my lord. I'm very sorry for that, my lord. She will kindly look into that person. And therefore, my lord, probably my name was not reflected in the cause dispute. In the main petition, my lord, WBC 3932, the name of the petition number 6 was written as Anjora, my lord, Begum. Miss case. My lord, I is for delaying, my lord, condoning the delay of 62 days, my lord, while preferring this, along with the mixed case, my lord, for restoration, my lord. Yes, my lord. I'm very sorry for that. You should have checked. Mr. Z. Ahmad and the counsel for the petitioner. Also heard all the respondents are there. Next para. By filing this interlocutory application, the applicant is applicants are praying for condoning the delay of 62 days in filing the connected MC 27 of 2025 for restoration of WBC 3932 of 2019 to 5. Next para. The learned counsel for the applicant has submitted that he has perused the wakalat number which is available in the records of Miss Case 27 of 2025, and he submits that there was a mistake on his part in filling up the wakalatnama, for which the wakalatnama filed in WBC 3932 of 2019 was lying defective with the registry. It is submitted that it was an inadvertent mistake on his part, and therefore it prays that the delay be condoned so that the connected MC 27 or 2025 can be taken up. Next paragraph. Although the learned standing counsel for the FT matters has opposed the prayer made, but considering the explanation tendered by the learned counsel for the applicant, the prayer is allowed. The delay of 62 days in filing the connected MC 27 or 2025 stands condoned. Most of this I stands disposed of. Miss case also we allow then? Yes. Next paragraph. Miss case 27 of 2025. But so next paragraph. Filing this miss case, the petitioners are praying for restoration of the proceedings of WBC 3932 of 2019, which was dismissed for prosecution by order dated 5/3/2025. Next para. Vakalatnama part, right, again. He has seen the records and Vakalatnama. That paragraph, you can go. Accordingly, it is submitted that on a bona fide belief that his Vakalatnama would be on record and his name would be reflected in the cause list when the corrected WBC 3932 of 2019 would be listed. There was a inadvertent error in missing out the listing of the case when the matter was called and taken up on 5/3/2025. Accordingly, he prays that the connected WBC 3932 of 2019 be restored to file. Next para. The learned standing counsel for the FT matters has opposed the prayer made in this application. However, considering the explanation tendered, the court is of the considered opinion that there are good and sufficient cause which prevented the petitioner to be represented when the matter was previously listed. When the corrected WBC 3932 of 2019 was listed and taken up on 5/3/2025. So accordingly, the prayer made in this miscase stands allowed. By restoring the said writ petition to file, for which separate order is being passed in the connected writ petition. It will listing as a main case to listing. I didn't know. Then don't say that. Last line don't say. You say that according to this, the prayer made in this miscase stands allowed. Next, para disundantly, the proceedings of WBC 3932 of 2019 shall now be re-registered by the not re-registered, shall be restored to file by the registry and thereafter be listed at the earliest. Deeply obliged, not deeply okay.
Production list item 1.
So just make one more order. The Vakalatnama which is available in the records of
My lord, in
the records of this MC 27 of 2025 shall be made a part of WBC 3932 of 2019. Then this list after this one is. Yes.
My lord, in your lordship's judgment, my lord, in W number 215 of 2024, there has been one slight mistake in the order, my lord, judgment at page 27, I have annexed, my lord. In paragraph 24, the order that should have been single bench order that should have been 23/4/2024. It has been wrongly typed, my lord, as 19/6/2024.
Okay.
The Julius, my lord, in paragraph 26
Then
also same thing has happened.
Why you are missing the opportunity? You get a right to appeal.
My lord?
For mistake, you had a right to appeal.
No, my lord, because these orders passed by this bench, my lord. Our lordship is retiring on Monday, my lord, so we are worried. So
So you did not want to go there.
Yes.
Okay. We make correction in the order.
Yes. Only that.
Yes.
And we're missing her since Tuesday.
No, you don't think so. Don't think so. We don't miss good people. We may not see them, but we don't miss. We really can't.
No, we
say that we are missing.
So far, I
We-
was fighting with her with my lordship for many days, in many cases. Obliged, my lord.
Heard Mr. R.P. Sharma and counsel for the applicant, as well as Mr.
W. Raman on behalf of A. Sharma.
W.
Rahman.
Sharma, appearing on behalf of, learned counsel appearing on behalf of Mr. A. Sharma, learned standing counsel for the respondent number 2. Mr. Goswami, you are there is CGC. Then you can appear here also. Respondent number 1 is there. We are disposing of this typographical error in the order. As well as Mr. UK Goswami, learned CGC appearing for respondent number 1. This respondent number 2, make it respondent number 2 to 2 to 7.
The some number 1 is union, others are same party.
2 to 7.
You can,
And
Mr. Sharma.
Mr. Goswami
one of
for
Sharma.
number 1. Next para. Filing this interlocutory application, comma, the applicant who is the applicants who are the you are the writ petitioners.
Yes. I was the petitioner, then that was allowed, and your lordship is also, the BBCL came before lordship in appeal. Appeal was dismissed, and your lordship has passed very, using Latin word, my lord, very strong language. Put me Pigore. Paragraph 26, my lord.
No, then your cost title is wrong.
My lord?
Then your cost title is wrong. Your cost title should have reference to the writ appeal. You have given reference to writ petition. That's why we are searching.
No, it is in the editable. In the matter of application, review the.
No, see page 2. See page 2. In the matter of writ petition.
Oh, there is writ petition is also given number, but first page you also can see. First cost title.
First
title. In the matter of an application, review the typographical errors.
No, we understand, but you see, you are giving us a cost list of cost title of 27253, but the appeal was filed by somebody else. It was filed by the Brahmaputra Valley Fertilizer. So the cost title is wrong. You'll have to make correction.
And the 75 things are got to see.
Appeal cost title is not there.
It is there, my lord.
No, it's not there.
in WA number 215.
No, that may be there, but the cost title is not there. It will not come in the correct order in the orders. When we pass orders,
yes,
our orders are only the text. They take out the cost title from the internal server. So your cost title will be wrong. The appellate cost title will never come. You'll have to file a amended cost title. Just see, so are present. Next para. It is observed that though the prayer in this interlocutory application is for correction of typographical error of date which has appeared in paragraph 26 of the judgment and order dated 13/6/2025.
Paragraph 24 and 26.
Okay, 24 and 26 of the judgment and order dated 13/6/2025, passed in WA 215 of 2024. But the cost title, but there is an inadvertent mistake in the cost title of this interlocutory application where the parties are referred to as per their position in the writ petition, that is WPC 7253 of 2019. Full stop. Next, under such circumstances, Mr. R.P. Sharma, and senior counsel, assisted by Miss
M.
Sangmai. Then counsel prays for some time to file an amended cause title. Post of the prayer is allowed. Let the amended cause title be handed over to the AOJ writ appeal section for being incorporated into the writ petition, and thereafter the matter will be listed again as and when the corrections are done.
Monday, my lord.
Whenever you do it, if you can do it today, it will come on Monday.
Because my lord, again, her lordship will be not there, not there.
No, that can't be helped because we give you liberty. You do it today, you will come because we have set the order. As and when it is correct, it will come.
My lord, in your lordship's order, my lord, it is writ petition is mentioned, not the writ appeal. Writ petition is all right. 7253 is our writ petition.
No, no, but that is we are upholding that.
Yes.
But the problem is the cause title here at page 2.
Yes.
If this is there, then the orders, all orders will be mistakenly coming.
No.
Certified copies will be wrong.
No, no, my lord, 7253 is written here because the order is corrected in reference to that order in 7253. That's why it's given.
No, no, then it will go to the single bench. Order of the single bench can't be corrected by division bench.
Or orders by your lordships in the appeal. But
You understand? But
yes.
then the cause title must be of the writ appeal. It can't be of writ petition.
No, writ appeal is given, my lord, here.
At least I don't find it.
My lord, in first concern,
We'll ask Mr. Sharma to.
judgment order dated so and so, passed in the WA number
No,
15.
Mr. Sharma,
Yes.
let second Mr. Sharma look into it and then tell you.
I think it is correct, my lord.
No, it's not correct. Just see and tell Mr. Sharma. Okay, Mr. Nath, in that matter, we have not been able to open this. So, hmm?
Now the pen drive is working, there is a password. I forgot.
Okay.
It's working.
Okay.
Sorry, but I forgot to.
Did you?
I have given the password and the pen drive.
Okay. You've seen it opens now. And put it here. Let others not see it. Huh? Then chamber, better. Chamber. We look into the chamber.
Upgraded item 22.
Yes.
May I please, your lordship? Lordship, I make a mistake in read petition, name of the district, my lord. Originally, the petitioner from Gwalpara district, but he contested the case in Kamrup Metro, FT number 1.
Okay.
Kindly direction may given to appear before the Superintendent of Police Border, Kamrup Metro, my lord.
Okay. Okay. Heard Mr. M.U. Ahmed, Land Counsel for the petitioner. All the respondents are there. Next para. By filing this interlocutory application, the applicant seeks to substitute the name of the nomenclature of respondent number 5, i.e. the Deputy Commissioner, Kamrup Metro, District, Deputy Commissioner, Kamrup Metro, with the nomenclature of District Commissioner, no, again you have made the same mistake.
I'm not in IA.
In the cost title, you are again making the same mistake. Again, there is Deputy Commissioner in both the cost title. You want to implement Deputy Commissioner, District Commissioner.
My lord.
Look at the cost title at page.
At page 4, my lord, in IA. Deputy Commissioner, Kamrup Metro.
Again, Deputy Commissioner. It has to be District Commissioner.
And so in 6. In respondent number 6, Superintendent of Police Border, Kamrup Metro, my lord.
But the nomenclature of respondent number 5 is still mistake.
My lord, I am allowed to correct it, lordship.
No, but now under the circular of this court, you'll have to do it by submitting a amended cost title. And the Superintendent of Police is Border Kamrup.
Yes, yes. My lord,
Where is the bail order?
bail order is, your lordship, 9/5/25.
Okay. Okay, we are allowing this. We give him 2 days time to amend the cost title. The issuance of certificate copy will be delayed till correction. No, then the write a fresh order. Heard so and so. Next para. By filing this interrogatory application, the applicant is praying to substitute the respondent number 6 in WPC 2408 or 2025 with the correct nomenclature of the concerned Superintendent of Police within bracket B border. So it is submitted that in the cost title of the writ petition, comma, there's a mistake in referring the in reference to the Superintendent of Police border, which is stated to be of Gwalpara, comma, which ought to have been Kamrup Metro Guwahati. Full stop. The prayer made in this interrogatory application stands allowed. For substitution of Superintendent of Police border Gwalpara, TO2, Superintendent of Police border Kamrup Metro. Is it Superintendent of Police or it is the Deputy Commissioner of Police? It should be Deputy Commissioner of Police. Oh. Then you are wrong. You have to correct it.
My lord, my lord.
Just take it out. Heard so and so. Next. The learned counsel for the petitioner has submitted that there is made a mistake inadvertent mistake in heading of respondent number 5 and 6 in the connected writ petition as well as in this interrogatory application. And accordingly, he prays to allow him to file a freshly typed out cost title for this interrogatory application. Stop. Next part, the prayer is allowed. The amended cost title shall be submitted to the AOJ FT section in respect of IA number 1813 of 2025, as well as in the connected WBC 2408 of 2025. Full stop. List the matter as and when the amended cost title is submitted and made a part of record.
Fine.
Make a request there, it will come.
Obliged.
Yes, Mr. Mandal.
I'm extremely sorry, my lord. Item 79, IA is there for my lord seeking bail, my lord. Can it be posted Tuesday, my lord?
79.
Monday.
Okay. 79 Tuesday.
Developed.
Okay.
Lordship, item 24 can be fixed on Monday.
Monday we are not taking up matters. Tuesday, perhaps. Item number
24.
Okay, 24 also Tuesday. Okay. So due to positive time matter could not be taken up today. Let's transfer.
Pronouncement of judgment, item 25 to 71.
In view of the discussions made in this order, the appeal is partly allowed. And the judgment and order passed by the London single judge is set aside, subject to following. In respect of the appellants who are not in service, the first is that the appellants shall be restored back to service prospectively from 15 days from the date of the order. The period for which the appellants are not in service, they would not be entitled to any back wages. However, the notional pay shall be taken into consideration while fixing the current salary from the date they are prospectively reinstated in service. It is open to the state to keep the appellants either without any posting or with such posting which will not hamper the proceedings already initiated against them. With liberty to initiate departmental proceeding against the appellants. And this is also for the disciplinary action or the criminal proceeding initiated against them is brought to its logical conclusion. This order shall not come in the way for the competent authorities in the government to initiate departmental or disciplinary proceedings against the appellants in such way as they may be advised. Insofar as the appellants in the Assam Police Service whose period of probation are not completed, the competent authorities shall pass appropriate orders as may be deemed fit and proper. Insofar as those appellants whose probation period is not completed, they would not be entitled to be restored in service. However, in respect of those appellants, the competent authorities in the government shall pass appropriate orders to withdraw the discharge order already passed and substitute the same with the simply cited discharge order of not having found them fit for confirmation. Ms. Chaudhary, the last case cited by Mr. Arnab Chaudhary was on certain conditions which were granted. Can you identify that case? We have not been able to track out that one.
Yes,
Please give that number to the courtmaster. This order shall not be implemented for a period of 1 month from the date of this order. After that, it will become implementable.
Deeply obliged.
Grateful, Lordship.
A copy, my lords. We may need a copy.
Yes, definitely you will get it.
Yes.
You upload it by Monday because there are some corrections, last moment corrections. We have done it so hectically.
Yes, sir.
There's grammatical mistakes. We can't even identify our own handwriting.
Okay, my lords.
Some-
Monday we will look on the website.
Yes, definitely you'll get it.
The Lordship, just for a clarification, the order is implementable 1 month after the order is available on the net or from the date of today.
From today.
From today. I'm grateful for that because that permits us the options if we wish to consider it. Grateful for that.
Yes. We okay, but it was a wonderful experience with all of you, especially the senior counsels who have argued, even Ms. N.N.B. Chaudhary. It was a wonderful experience.
Grateful for that comment, Lordship.
Grateful.
And as juniors, my lord, we have also learned a lot.
Yes, for us also, it was a learning experience. That's why we made a comment that it was a wonderful experience. And we never thought we would be, we could do it on time.
We always had the
But
confidence.
in this process, there are some typing errors are keeping in.
That's it, that's it.
So, thank you.
Obliged.
There's one more item which I'd like to take up.
78 Pro. And we can-
Item 78 for orders fixed at 4:30 PM.
7:30. We are segregating that.
Yes, ma'am. That was the chair.
All sides are duly represented. Mr. N. Gautam, learned counsel for the petitioner, submits that during the pendency of this appeal, the appellant has been convicted in special case number 5 of 2021, which arise out of Mahagar PS case number 159 of 2017. Therefore, it has been prayed that the matter be taken up separately. Accordingly, as there is no objection to the said prayer, the matter is segregated from the bunch of appeals so as to be taken up separately. This matter shall not be treated as parted matter, lest the matter after ensuing some eviction or date to be fixed by the registry.
Deeply obliged.
And
Very kind.
there's one more matter that police.
Item number 1.
Item number 1. We'll be switching off the video conferencing.
Madam.
Others believe this is a police matter which we have to look into the video. We shall just identify that case.
That is Sarita Chaudhary, Lordship. Sarita Chaudhary, Mr. NNB Chaudhary also relied on that judgment. 2025, I can give the citation in 5 minutes. The last judgment shown by